Welcome to What to Do When a Loved One Has an Incapacity or Passes Away, a webinar presented by the law firm of Pyke Associates. I'm Suzanne Presley, a lawyer with the law firm of Pyke Associates, and here with me today is...
I'm Shane Hunter, a financial planner with Stewardship Financial Advisors, and we appreciate you guys joining us today.
Our purpose with today's webinar is for you to understand the process of when there is an incapacity or a death, legally, financially, what we're going to go through, the items that we're going to have to address, the things that we need to be aware of. You may have some questions or comments while we're going through the webinar, so we encourage you to get a piece of paper, a pen, jot down those questions. That might be a good reason at some point for you to come in, talk to one of our firms so that we can help you understand what you're looking for.
So the original intent when the firms were started was really to cover those two adages, what are the two constants in life? Death and taxes, right? And so with the three firms, you've got the legal, you've got the financial, and you've got the taxes. And that's our whole goal here, is to put three firms in front of you in one building, in one place, to have all the appropriate professionals to help you through this part of your journey in life.
So as we start to think about an incapacity, I want you to visualize somebody that you love. See them as they are now. They're healthy, they're happy, they're living a vibrant life. Then you get the phone call that changes everything. Whether they've been in a car accident, they've had a stroke, a heart attack, we're now in a different place. Where do we start? What do we look for first? From the legal perspective, typically the first thing that we're going to need to find is whether or not the individual has a healthcare directive. In 2007, Georgia began using the Advanced Directive for Healthcare. That document incorporates what was once referred to as a living will or a healthcare power of attorney. It allows us to appoint someone to make our healthcare decisions, as well as us state for ourselves what our end-of-life preferences would be. That document is really important for us to not only have, but for our healthcare agent to understand where it is. That document is what's going to allow somebody to take over when we're unable to do so. And often that occurs when we have a long-term care event. Now, a long-term care event for our purposes is when an individual needs assistance with one or more ADLs. An ADL is an activity of daily living. That might be getting your medicine, going to the restroom, taking a shower, moving from the bed into a chair. When we need assistance with one or more activities of daily living, that's technically the beginning of a long-term care event.
And when we have that long-term care event with a loved one, we run into a situation where we're overwhelmed. There's a lot of things that need to happen. And on top of that, you're dealing with a loved one who is sick and needing care. So we developed a book that we call the FEHL book. That's FEHL. It's Financial, Environmental, Healthcare, and Lifestyle. And the purpose of this book is really to identify the different parts of your life that you would need to take care of if you were to have a long-term care event. And so by design, it would be, if I had a long-term care event 1 year from today, what are the things I need to accomplish or put in place between now and that time period? So the book is laid out so that each month you're going to do one in each area. So you're going to do 4 things a month over the next 12 months, so that if you were to have that long-term care event, your life, your house, whatever would be in great order. And so we hope you don't have that event, but again, that FEHL book will help put you in a position where you're able to plan for a long-term care event. So it's one less thing you got to deal with, and you can just focus on taking care of your loved one.
Our objective, like today's webinar, is to inform and educate so that regardless of what situation we're in, we're prepared for what it's going to feel like, what it's going to look like. And with clients on the law firm as well as the financial advisory firm side, it's key to our relationships to be able for us to help you to know that moving forward, you're in a position to understand what an incapacity would look like, how it would affect these key areas. Then today's purpose, this webinar, as well as many client interactions we have, is to translate that information to the fiduciaries, the individuals who are in charge, whether that's a healthcare agent or later we'll talk about an executor, making sure that we're all aware of what are our steps. And one of the things that occurs with a long-term care event, an initial step after the healthcare, is the finances. How do we pay for that kind of care?
And a lot of people aren't prepared for it. Not only the cost, but the longevity of it. The numbers are staggering. The statistics are something like 65% of all couples are going to end up, one or maybe both are going to have a long-term care event. And that's a pretty staggering thing. So for most of you that are watching this, you've already seen this either in your personal family or with friends. And so this is probably resonating with you. And then when we talk about, all right, the majority of you are going to have an event, well, let's talk about how long it's going to last. So as Suzanne was saying, it typically starts in home, right? Everybody wants to stay home, and they want to stay home as long as possible because nobody wants to go to that facility, right? They think if I can just stay home, I'll get better. What we find is you're typically going to be at home for maybe 18 months, maybe 2 years. And then as you start to progress through care, you'll go to assisted living, potentially even to a full-blown nursing home, and then maybe even into hospice care from there. So the medical care that's available is phenomenal. We do a really good job in the medical community of keeping us alive. The care is there. The medicine is there. But one, it prolongs life to some degree. We don't necessarily have quality of life, so it lasts a lot longer. And it gets more expensive. And so when you're staying at home, people think, gosh, well, I'm going to stay at home. It'll be cheaper, right? I don't have to pay for that facility. Staying at home is a lot more expensive. There's no scale there, right? There's one nurse to one patient, and 24-hour-a-day care at $25 an hour becomes astronomical. That's about $10,000 a month. Most people don't have that extra money in their budget. So if you can get to an assisted living home or even a nursing home, you're not at home where you're comfortable, but the cost of care is cheaper. And a lot of times that care is actually a little bit better because when you're at home, it's a family member trying to give you the care. And oftentimes those family members aren't as qualified. They're not, RNs or PRNs to give you that level of care. So we want to encourage our clients to put themselves in a position financially to be able to get the care they need, but allow the loved ones to be a loved one and not a caregiver.
What's really relevant for us is that you understand what your options are. Not only for yourself, educate yourself. I think one of the best things that an individual can do is really look at the options related to long-term care insurance. Can you insure against long-term care costs? Then you have many options. You might choose to stay at home. That does come with its own issues of having an individual in your house. That's not bad care, it's just different than assisted living or nursing home. But educating yourselves to understand, can you self-insure? Is there a government benefit that will pay for your care? Should we have long-term care insurance? What are our options? And then at the point that we're in that situation, we now need to activate whatever that care plan is. How do we do that? On the law side, it's, do we have a financial power of attorney? That document is key to being able to help someone through a long-term care event. Now, a financial power of attorney in Georgia, it is codified, meaning there are statutory requirements. It's a document that needs to be well executed, well thought out. It needs to cover so many different topics because if I'm in a position where I can't act for myself, my agent needs to be able to do anything in the financial realm that I would be able to do on my own. So a power of attorney, it's key for you to have. You want to make sure that your agent understands how to use it. Is it effective the day you execute it? Or do we need to have a doctor state that you're incapacitated, that you can't make decisions for yourself before we use it? Those are things that you need to know about your own power of attorney. You also need to know it if you're the agent, the fiduciary, the person appointed to act. It's also really relevant for you to be aware that powers of attorney are invaluable, but they have to be kept up to date over time. If not, if that power of attorney isn't accurate and well maintained at the point that you really need it, it might not be there.
Yeah, and on the financial side of the house, that's where we see most of the frustration is when that agent is coming in to present that financial power of attorney, it's out of date or it's not adequate, so it's not valid. And so it leads to a lot of frustration. So again, you're trying to get these financial affairs in order that aren't yours. So you're trying to play a little bit of catch up, and you've got a document that you thought was going to work and now it doesn't. So you've got one more hurdle to go through. So you've got to be proactive, not only with your own plan, but again, if you're going to be the agent for someone else, you need to be proactive to understand that they're keeping it up to date to make your life as easy as possible.
That's one of the things that we hope you learn from today's webinar, is that maintaining your documents so that your advance directive for healthcare, your financial power of attorney are not only documents that you've executed, but they're also kept up to date so they're available when we need them. The hardest thing to do is care for somebody that you love and also have the administrative duties. And because a long-term care event starts when we're still at home, typically, and it can last many years, it's a juggling act for a really long period of time. I want you to think back to the beginning of our webinar, and we had you pause and consider an individual that you care about very much. And that person was in life and doing well, and then they had an incapacity. Well, as we know through life, what will happen next is that eventually that individual will also pass away. And now what do? What is our first step? Well, as a client of the law firm and the financial advisory firm, the first step that we want you to take, one of the very first calls that you make, is to our office. Our purpose in asking for that first call is so that we can be there at this critical time to guide you through the process. There are important decisions that have to be made. We need to make sure that you're aware of what those are. Sometimes they're financial. How do we pay for the funeral? They might also be administrative. Where do we put as the residence on the death certificate? Those might be strategic things that we can help you walk through before you get too far in the process. Now, when you call our office, what we're going to be doing is setting ourselves up to set an appointment with you. That appointment is typically about 2 weeks after somebody passes away. If you're a client of the law firm, we're going to have gotten your estate planning documents ready. Those are documents that the individual, the decedent, that's the person who passed away, signed during life, that we're now going to implement the roadmap that they set up for us. On the financial advisory firm side, they're going to be helping us determine what you own.
Yeah, and so one of the things that we can do from a financial advisor perspective is help our clients to understand everything they have. Where is it? How is it titled? Who are the beneficiaries? And so one of the probably the best thing we can do for our clients is what we do is create a net worth statement. We're householding everything together so they know where everything is, whether it's a bank account, whether it's an investment account, whether it's a life insurance policy, whether it's a number of pieces of real estate, putting all that together for them. And then not only do we do that, but we make it available to them on an online portal so they can go in and make edits to it as they need. If there's, closing bank accounts, adding new bank accounts, so that we've got an up-to-date snapshot of where everything is housed. And that's really vital when our clients come in that are also law firm clients, when they're going through this estate administration process, and we're able to present that to the law firm and say, hey, here's everything we know about them, and we just met with them a month ago. So this is going to be really accurate. So if it's not the spouse who's coming in, or maybe it is the spouse who's not overly involved in the financial side of the house, if you will, we can give a very accurate depiction of what's going on. And it makes the law firm's job very easy to walk through that estate administration process and help you guys identify what needs to happen.
I think that one of the keys of the relationship that we have between the law firm and the financial advisory firm is that we have our eye on that potential meeting throughout the course of our relationship with our clients. It is inherent in everything that we do. When we meet with you during life, one of the considerations that we have is eventually there will be an estate administration. What will we wish that we knew? What information will we want to have already ready in our file? And the portal that he talked about is really helpful because it not only allows us over time to be kind of a check and balance. All right, you've told Shane this is what you have, but I'd also like to know who the beneficiary is. Or was there a group life insurance policy? I don't remember that being mentioned. It helps us help one another, which eventually affects you and your family. It also not only allows us to talk about what we own, but also what we owe. What are our debts, our expenses? The person who needs that information is called the fiduciary. If we have a last will and testament, that's going to be the executor. If we have a revocable living trust, that's going to be the trustee. Now, today, as we talk through an administration process, when we're discussing a trust, it is going to be a revocable living trust. There are lots of other types, but that's the one we're going to talk about today. When we start with an administration, we know what we own, we've got an idea of what we owe, and now we know what document we're dealing with. We're either dealing with a last will and testament or a revocable living trust. And one of the first decisions we make is, are we going to need to go to the probate court? Is there something that we need to do that a probate court will oversee? Well, that typically comes back to whether or not we have a will-based plan or a trust-based plan. Let me be clear, because sometimes it's confusing. If we have a revocable living trust, we might still have to go to the probate court. But if we have a will-based plan, we will almost certainly have to go to the probate court. Probate is not a scary process as long as we're prepared for it. And preparation is key. The first thing that we need to decide in determining what that probate process will look like is our will valid? Simply because you executed one doesn't necessarily mean it's still valid when we need to use it. There are things that we do in life, like writing on a document, that might invalidate it. Getting married, getting divorced, having a child. There are actions that we can take through life that will have an effect on the validity of the will. And so whether or not we have a valid will is our first question. And then, is there anything missing in the will that might make the probate process a bit more comprehensive or complicated? We want to know the answers to those questions before we ever send the executor that was nominated in the will to the probate court. Because the probate court is going to look at the will. That's the only thing the decedent, the person who passed away, that's their voice. And that's what the probate court is going to look at. So we want the executor prepared when they actually go. We want to make sure that that will is ready for probate, that all of the appropriate signatures are there, that when the executor goes to the probate court, it is as smooth a process as possible. Now, once the probate is complete, we now have an executor. Typically, that's going to mean the issuance of what's known as letters testamentary. When we have an executor, or when we've completed the formalities to have the new trustee appointed over the trust, that doesn't involve the probate court. The administration thereafter, it's basically the same. And the fiduciary's first job is now to make sure we've inventoried the assets and we understand not only what we have, how they're titled, who the beneficiary is, but what is the value of each of those assets.
And a lot of times on the financial side of the house, when we're trying to determine value, it's really easy. If you've got an investment portfolio of nothing but stocks in there, it's really easy to get the date of death value, or literally what it means, the value on the date that the person passed away. So we can go look at the closing price for Home Depot, Coca-Cola, Apple, whatever that stock might be. So for all of your marketable investments, it's really easy to determine value. For those of you that own houses or you own real estate, that's a little trickier. We have to get an appraisal. Suzanne will mention that a little bit later with some of the costs that go into the estate administration. So we can get an appraisal, we can get all of these values. But related to what you own and how much it's worth, we also have to establish cost basis, because cost basis is going to help us determine the taxation. Some of these assets will be transferred on what we call in kind. So we can just move them on from, Apple stock from grandma down to granddaughter. It doesn't really matter. We're not selling it. We don't have any cost issues. But if we've got assets that we're selling, we want to make sure we have accurate cost basis so that we understand the taxation on that. And so when a person passes away, we get what's called a step up in basis per the IRS rules. And what that literally means is the value is stepped up to the date of death, but the cost basis is also stepped up to that date of death. So for instance, let's say that both of your parents have passed away and they're moving that house as being passed along to you as an only child. Well, they may have bought that house back in the 70s, right? They may have paid $20,000 or $30,000 for a house, and today it might be worth $300,000. Well, you don't want to have to pay taxes on the gain, $270,000 or $80,000 worth of gain in the property. You get a step up in basis to today's value, which is the $300,000 number. So you could turn around and sell it the following day and pay no taxes. Well, why is that a big deal? Well, the person who, is passing these assets to you, they worked really hard for them and they want to pass them to you in the most tax efficient manner. And so the fiduciary, the executor that's taking care of the estate, that's going to be their role as well, as to not only value the assets, but also to determine cost basis. And that's where working with your financial advisor is going to come back into play. They're going to help you do that as well.
It's really important that we have a financial advisory firm that we're working with through that, because for most of our clients, there's going to be a retirement account. Maybe there are stocks or bonds, and it's key for us to understand what's the value as of date of death, what are the tax consequences of claiming or liquidating an asset, and what's the most advantageous way to do that. And so when we sit down typically with the law firm, the financial advisory firm, the fiduciary, and we make really intentional decisions, asset by asset. What do we do with them? Now, once we have those assets, we've consolidated them. We know what we own. Now we are looking at what we owe. And who do we pay and when? So one of the first expenses that you're going to have is the funeral home. Well, that's an estate expense. We need to make sure that if someone paid for that up front, or if life insurance was used, that that's allocated appropriately. We might also have probate fees, but then there are debts, not expenses related to the estate, but maybe there's a mortgage or credit card. We need to know how to deal with student loans. We need to understand that the car can't be titled differently until that debt is paid off on it as well. And so when we're looking at assets, we're looking at what do we own, what do we owe. In Georgia has a very specific order of how we pay debts and expenses. Some of those are fairly obvious, like I mentioned, the funeral or credit card debt. Well, credit card debt is very low. We're going to have paid all of our secured expenses like the mortgage. We're also going to have paid the IRS, because in every administration, key to our completing the process is making sure that we've accounted for both income and estate taxes and that we filed the appropriate tax returns.
When we've taken care of the personal income tax, again, coming due on April 15th of the year following the death, we potentially have to deal with an estate tax return. In your situation, you may or may not have one due. That's where we would refer you back to the law firm. They'll walk you through those steps. It's pretty meticulous. And now that we've taken care of the income tax or possible estate tax, how do we pay for this? What assets are we going to liquidate? Where's the money going to come from? How do we liquidate the estate? How do we get the assets to the individuals? Are we moving, individual stocks? Are we giving them cash? And it's a really tricky process because depending on how the will is set up or the trust is set up, things may be, those assets might need to go as cash. They might be specific bequest. And this is where things get tricky and we see most of the horror stories that come into play. One of the things that we run into a lot of times is with annuities. Annuities here in Atlanta anyway get a really bad name just because they're a little bit of a different investment, but annuities are very tricky at death. They don't get a step up in basis. If they are taxable, they're going to get taxed as ordinary income, which is your highest tax bracket. And we've seen a number of times where clients have gotten some bad advice from advisors, from financial advisors, not from us, obviously, but they've gotten some bad advice from financial advisors, and they liquidated those annuities and created large taxable events. And when I say large, the taxation in one event alone was about $11,000 that the estate had to pay. Well, why is that a big deal? That's $11,000 less that the estate gets to pay out to the beneficiaries. And if you're a beneficiary, that's a big deal to you, right? The other thing we run into a specific bequest, and I'll let Suzanne give a little bit more of the story, but the specific bequest is where you identify a certain asset that you want somebody to have. And we're not talking about the grandfather clock or something like that. We're talking about, a piece of a stock, holding or something like that.
It's important when we start liquidating assets that we know who the beneficiaries are of the will or the trust so that we understand what they're entitled to. Did I leave in my will that Shane gets a house, or did I say he gets 1/3 of everything? We have to begin with that sort of end in mind so that when we pick the assets that we're using to liquidate, to pay debts, expenses, taxes, that we're intentional about that. We always have to keep in mind that we have a testator or a grantor, the decedent. The individual who created these documents, they were purposeful in what they wanted. We have to make sure that we're guiding the fiduciary to meet the objectives of that individual. So if I say that the house goes to Shane and then we've sold the house, then we no longer have that asset and we have unintentionally disinherited Shane. So intentionality is very important for us in an administration process. That's not only to protect the beneficiary, it also protects the fiduciary, because in Georgia, there are very specific lists of who we pay and the order in which we pay them. And if we get out of order, if we pay expenses that we should be waiting for and we run out of money, now it's the fiduciary who's responsible for that. It now might become a personal liability issue. On the flip side, Shane mentioned annuities. They do get a bad rap. But it's simply an asset that has consequences that we have to pay attention to. And if the fiduciary is misguided and doesn't realize that there is a tax implication or a penalty for claiming something in an incorrect manner, who's going to be responsible for that? Well, it's not the beneficiaries. They're likely to not want to take responsibility for a choice they didn't make. And so as the professionals who are guiding you through this process, we want to make sure that we're limiting or eliminating, that would be the goal, any personal liability the fiduciary has. Because ultimately we want to get to the place where the debts have been paid, the taxes have been filed, we're left with the assets we intended to be left with, and now we're ready to actually distribute them to beneficiaries. The distribution phase is the final step in the administration process. We're now at the place to transfer the assets from the estate or the trust to the beneficiaries. And one question that fiduciaries have is, how long will that take? Well, the time frame is different for each administration, but on average, an administration process will last approximately 6 to 9 months. If you have a complicated administration or an estate tax return is due, that might be a bit longer. We are always aware of IRS deadlines, and those are typically what will make the process be a bit longer. The next question that we get from the fiduciary is, how much will this cost? There are legal fees, tax preparation fees. There might be the cost of an appraisal or a date of death value that we need to obtain. I would say that in general, an administration is going to run between $2,500 and $4,500. One of the fees a fiduciary might be interested to learn as part of that is their fee. Whether you're an executor or a trustee, you are entitled to a fee for your service in administering the estate.
So we've put all this together in an effort to help you to be a good steward, right? And that's really our motto at the three firms, is helping others to be a good steward of everything that's been entrusted to them. And for those of you that are a client of both firms, you've already seen this. You've seen us work together, the law firm, the financial firm, and even the tax preparation firm. You've seen us working in concert to help you and put you in a better situation. For those of you that are a client of one of the firms, you've seen a little bit of that work for you, but you may not have gotten the full benefit of both firms. And if you're only a client of one firm, we would encourage you to come in and meet with the other firm that you're not dealing with. And for those of you that are watching this that are not a client of either firm, we would encourage you to come in and meet with us. So for those of you that had your piece of paper out during this presentation, you're writing down the questions, we want you to bring that in when you meet with us, because we want to answer those questions to the best of our ability. I know on our side, one of the most common questions we get during this administration or incapacity process is, how do we deal with IRAs? Whether it's a loved one who's had an incapacity, how do we get money out of the IRA? If we do, how's it taxable? Or at the point that somebody passes away, how do we pass that IRA along to the beneficiary in the most tax efficient way? And it really depends on who the beneficiary is, who the owner is, how that's going to be taxed. So if that's one of the questions, we definitely want you to come in and sit with us and let us help you with that. Suzanne, on your side, what's a common question you guys get?
We had a lot of questions about what happens when we have the will. How do we know whether all the formalities are up to date? Who has to sign that petition that's filed at the probate court? Is that beneficiaries? Is it family members? It's knowing what to file and when to file it. If we have a revocable living trust, then oftentimes the questions are related to how do we give the assets to the beneficiaries? Are we writing them a check? Are we transferring them in kind? It again goes back to we need to have so many questions answered about the specifics of the administration to really know how to fully provide guidance.
One of the things we hear on our side, but it's really related to you, is there any way to speed up the probate court?
So no, there really isn't, unless we're in an emergency situation. The probate court process is a process that we go through that we really are governed by the judge and the judge's schedule. However, keeping the will up to date, maintaining it, making sure that it covers all of the formalities of Georgia is really the key to making that process as smooth as possible. We say you don't know what you don't know. And there are often times that individuals come in with wills that we did not draft that are missing a couple of components. And that can add 4, 6, even 8 weeks to the probate process. So can I speed it up? Maybe not. Can I ensure that it's as efficient as possible? Right. Absolutely. That's a great question.
So for those of you that have other questions that we didn't address in this little short Q&A, we encourage you to, either give us a phone call, shoot us an email. All of our contact information will be in the description of the video. But we encourage you to come in and meet with us because every situation is going to be different. We don't want to give you some generic information here today that you kind of take and run with, and now we've done you more harm than good. And so we would just encourage you to come in, meet with us, sit down with us. We're happy to take the time to do that for you. And we always want to thank you for listening in and watching these videos with us. We really appreciate it.
We also encourage you, if you've learned something today, to share the video. If you have another family member or a friend who might be concerned about incapacity or somebody passing away and being kind of overwhelmed with that process, we encourage you to share the video and hopefully they learn something else. Thanks for joining us.